to go ahead and ask you to please mute your audio and your video so that we don't have any interference in the recording for today. I also want to say thank you to the University of Cincinnati Law School for hosting today's programming and tomorrow's programming on WebEx, so that and for all the tech support that's been provided, especially from Michael Whiteman. Thank you so much. So just wanted to chat with you today about a slogan that I recently read. Ben Crump, who you may know is part of the National Bar Association. The National Bar Association is the African American national bar organization. And Ben Crump does a lot of civil rights work. He had a t-shirt on saying Black Lawyers Matter. And of course, it's a play on Black Lives Matter slogan. But I thought, yeah, I like that shirt. And it harkened me back to 2009 when I published an essay examining the role of Black lawyers in our democracy. And in that essay, I had attempted to highlight the important role that Black lawyers play in contemporary American democracy. And I argued essentially that African American lawyers served three functions in our democracy that operated to improve and enhance citizenship as participation for Black Americans. And the first thing that I argued was that Black lawyers serve a representative function in our democracy by serving as representatives of the African American populace in our democracy. So they serve as ambassadors to democratic institutions, such as our courts and our legislatures and our executive agencies, and thereby ensure that there is representation of Black experiences and a commitment to the very diverse and varied interests of African Americans in the deliberative process that precede a lot of our democratic decision making. So there are, at least some Black perspectives offered in this deliberative process, and so I argued that African American lawyers or Black lawyers serve this representative function. I also argued that Black lawyers serve a legitimizing function in that our very presence in government tends to promote public confidence in governmental institutions, such as confidence in our courts. There had been a study, I'm a member of the Pennsylvania Bar, and there had been a study commissioned by the Pennsylvania courts that found that when African Americans saw themselves represented as judges or lawyers in the court, that they felt that they would be treated more fairly. And so they felt that there was more institutional validity and that the institution had more legitimacy when they saw themselves included in the representation of the bodies that made up the court system in Pennsylvania. And so when Black people see individuals from their racial group represented in democratic institutions, these corporal representations lend legitimacy to those institutions and therefore strengthen those institutions. And finally, I argued that Black lawyers serve an interpretive function by speaking the language of democracy and being able to translate that language into arguments that are meaningful and helpful to the Black community. So Black lawyers have the privilege of receiving the education and the training to serve this interpretive function and being able to communicate the concerns of varied perspectives in the Black community to our democratic institutions in the discourse that those institutions both understand and value. And so, I thought it was important that I point out that Black lawyers have that training that, not every lay person is able to communicate effectively with their democratic institutions. Finally, I pointed out that Black lawyers serve this connective function by acting as this kind of conduit that affords Black and non-Black citizens of lesser economic means access to democratic institutions such as our courts. So there had been quite a bit of research showing that Black lawyers held this, subscribed to this obligation thesis that we had a duty to give back, and Black lawyers were oftentimes reporting that they had done pro bono work at a rate higher than white counterparts, and oftentimes because of their social networks, under privileged African Americans who couldn't afford a lawyer were the beneficiaries of that pro bono work that Black lawyers performed. So in that way, Black lawyers serve this connective function. But when I saw Ben Crump's T-shirt, I said, you know what? There's something that I left out of that essay, which is, a fundamental axiomatic principle that explains for me why Black lawyers are so important to our profession and our system of justice and our democracy. And that was that Black lawyers bring a passion for racial justice to the work that we do. And so when I saw Ben Crump's T-shirt, that passion really was on display. And so I think within most Black lawyers, there resides this very personal commitment to the principle of racial equality and an intrinsic moral obligation to engage in anti-racist lawyering. We see this dating back to very early lawyers in our society. So Charles Hamilton Houston, for example, while studying at Harvard Law School, acknowledged his passion for racial justice and his passion for Black lawyers when he argued that there should be a Black lawyer in every community, particularly in communities in the South, to wage what he called an uncompromising fight for equal rights for Black people. After law school, Houston would ultimately enter legal academia and would come to teach at Howard Law School and become the dean at Howard Law School, where he saw it his mission to train Black students to become lawyers for the purpose of specifically engaging in anti-racist lawyering. In the decades since Houston's death, countless legal institutions have lauded the importance of diversity in our profession and have articulated a commitment to remedying the underrepresentation of Blacks and Latinos, which are also an underrepresented racial minority group in the legal profession. But one of the dominant values of the legal profession has been this bleached out colorblindness that Professor David Wilkins at Harvard has ascribed that name to it. So it's this commitment to colorblindness in lawyering, so that the professional socialization of law students pushes law students to have this bleached out professional identity. So you're not supposed to bring your race to lawyering. And Professor David Wilkins at Harvard really challenges that that thesis and says that not only is it okay for Black lawyers to bring their identity, including their racial identity, to lawyering, but that it's really it's important and it's morally acceptable for Black lawyers to bring their racial identity to lawyering. And I really think that I definitely agree with Professor Wilkins in that we bring our whole selves to lawyering, and I think Black lawyers bring their whole selves in bringing that passion for racial justice to whatever work that they do. So, you could be a corporate lawyer and still have a passion for racial justice by writing a check and supporting the work that people on the ground are doing in that area. So, Professor Wilkins has written about this notion that bringing your whole self to lawyering is morally acceptable. Professor Russell Pierce has also written about this concept. He's used intergroup theory to argue that the legal profession should discard this model of bleached out professionalism in favor of what he calls, quote, integration and learning perspective. And in this model, it acknowledges the influence of identity on lawyers' work and leverages the diversity of our identities and our group affiliations to achieve organizational goals. So when I look at the work that Black lawyers have done historically and contemporaneously, for me, it seems that Black lawyers overwhelmingly reject the norm of bleached out professionalism and retain a race-conscious professional identity. So another way of saying that is that I would say for most, if not all Black lawyers, becoming a lawyer does not cause one to abandon their racial or cultural identity. You don't have to shed your cultural identity to be a lawyer. The consequence of Black lawyers retaining their racial identity while assuming the professional identity of lawyers is that the lawyer typically can bring a race-conscious perspective to lawyering, and that race-conscious perspective oftentimes manifests itself as a commitment to anti-racist lawyering. And in this form of lawyering, lawyers are cognizant of how race intersects with our law and with our legal institutions, and how some people who have been assigned a racialized identity by our society suffer a negative disparate outcome when law is applied to them as a group. And so when I look at examples of this, I think of examples of Black anti-racist lawyering that date back to the birth of Black lawyers. When racial segregation was the law of the land, it was Black lawyers who challenged the racist decision of Plessy versus Ferguson. And it was white lawyers who defended the rule of law of separate but equal, and basically, stuck to the principle that as long as equal facilities or equal education was provided, that being separate was constitutionally permissible under the Equal Protection Clause. And I think of, not only Black lawyers like Charles Hamilton Houston and Thurgood Marshall, who began to attack the separate but equal principle in Plessy versus Ferguson, but I also think of Black lawyers who were educated by my own law school here at Washburn, who filed the case of Brown versus Board of Education of Topeka, Kansas, here in Topeka, challenging racial segregation in public school education. Their representation of the plaintiffs in that case was not merely lawyering detached of their identity. It was lawyering probably because of their identity, because their representation of the 13 plaintiffs here in Topeka, Kansas was very personal, because their success in that representation would impact the education of their own children and grandchildren for generations to come. So if you want to know more about African-American lawyers and their march toward racial justice, I have to put in a plug for my former constitutional law professor, J. Clay Smith of Howard University School of Law, in his book called Emancipation, the Making of the Black Lawyer, 1844 to 1944, where he examines a century of Black lawyering in the United States. So I highly recommend that book to you. A more contemporary example of anti-racist lawyering by Black lawyers can be found in the area of criminal justice. And we know that there are, through the work of many law professors throughout the country who've examined this, there are a lack of minority prosecutors in jurisdictions across the U.S. Recent data show that of the 2,437 elected prosecutorial positions in the U.S., only about 5% are minority. 60% of U.S. states have no elected Black prosecutors. And in at least a quarter of the states, all elected prosecutors are white. So when we look at the criminal justice system, we see a system that does not necessarily reflect the people of the democracy that it serves. Prosecutors, of course, have a lot of power. We've read about that in literature like the New Jim Crow and Paul Butler's work. And so prosecutors impact, whether to offer a plea, whether to, what charges to prosecute someone with, but they not only affect individual decisions on individual cases and particular criminal defendants, but they also have an impact on the very structure of our criminal justice system. Black prosecutors have proximity to the Black community. And I think Brian Stevenson talks about the importance of proximity in having not only compassion for the people, the clients that we represent, but also having a better understanding of their plight. And so Black prosecutors have this proximity to the Black community that provides a unique perspective with respect to the flaws in our criminal justice system, which includes the ability to recognize the prevalence of, for example, the condemnation of innocence and the disproportionate effect on racialized communities that condemnation has. You probably know that there's been a lot of research around DNA and developments with respect to DNA, and we've now have science that can conclusively identify the perpetrator of many crimes based on DNA. Well, DNA has been effectively used as a tool to demonstrate that many people who have been condemned to prison have been wrongfully convicted. And unfortunately, a significant percentage of those wrongfully condemned are racial minorities. But rather than turn a blind eye to the condemnation of innocence, one Black prosecutor in particular who came to my mind was Craig Watkins. And he was so personally disturbed by the condemnation of innocent people that he led the way in changing the structure of our criminal justice system so that fewer innocent people who have suffered a wrongful conviction would languish in prison. So his passion for anti-racist lawyering was perhaps motivated by the fact that his grandfather was rumored to have been wrongfully convicted of a crime during the Jim Crow era. So for Watkins, the wrongful conviction of people of color was personal. Craig Watkins was the first elected Black district attorney in Texas history. With the knowledge that not all people in prison are guilty, he persuaded Dallas County leaders to spend nearly $500,000 to create the country's first conviction integrity unit, which dedicated prosecutors and staff to investigating claims of actual innocence and reopening cases in which there appeared to have been a miscarriage of justice, even if the appeals for the criminally condemned person had been exhausted. Under Craig Watkins' leadership, the Dallas County District Attorney's Office helped exonerate 25 inmates proven innocent of their convicted crimes, 7 of whom had received life sentences. And as one might expect, a disproportionate number of these exonerees were racial minorities. Other Black prosecutors who understood the need to ensure the integrity of convictions followed Watkins' lead and launched conviction integrity units across the country. One brave African-American prosecutor who dared to change the structure of the system in this way and follow Craig Watkins' lead was a Washburn Law School alum named Mark Dupree, who presently allocates resources to running a conviction integrity unit in Wyandotte, Kansas. The creation of the Conviction Integrity Unit in prosecutors' offices across the country is an important step toward fulfilling the prosecutor's justice-seeking function. Prosecutors are there to seek justice, not merely seek convictions. And by fulfilling this justice-seeking functions, we reduce the number of people languishing in prison due to erroneous convictions, an outcome that we should all be proud of. Prosecutors who know their work may be reviewed by other prosecutors who will be looking for errors. This is likely to cause more prosecutors to be very careful in the administration of their duties, thereby lessening the likelihood of future erroneous convictions. Again, another positive outcome. And even when there is no prosecutorial error, erroneous convictions can occur in a system administered by imperfect beings, which we all are. So adding an additional mechanism to ensure the integrity of convictions is appropriate as an ex post measure to rectify erroneous condemnation. Nonetheless, restructuring the criminal justice system so that it has an additional post-conviction check on the use of state power has not been seen universally as a politically popular use of resources in many jurisdictions. Some have argued that such units are a slippery slope that erodes the sanctity of jury verdicts, as if the sanctity of a jury's verdict is paramount to the interest of innocent individuals to be free from wrongful condemnation and incarceration. By changing the very structure of the criminal justice system so that it is less likely to be a tool of racialized oppression that disproportionately incarcerates poor people and people of color, Black prosecutors have led the way for making our criminal justice system better. Because the moral force and legitimacy of the criminal law is diminished when the system that administers it raises doubt and suspicion whether innocent persons are being condemned, the dedication of state resources to ensuring the integrity of convictions will serve the laudable goal of strengthening the criminal law, not weakening it. Despite the positive impact that Black lawyers have had on our system of justice, presently only about 5% of lawyers in the U.S. are Black, although Black people make up nearly 13% of the U.S. population. This is true despite the fact that Black students aspire to a career in law at rates higher than other racial groups. Hence, Black Americans continue to be underrepresented in the legal profession despite their desire to enter the legal profession and the important role that they play in contributing to our democracy as lawyers. Both the National Bar Association and the American Bar Association and numerous local bar associations throughout the states have articulated on numerous occasions that Black lawyers matter to our profession and that they matter to the administration of justice. These laudable professional organizations have launched programs and task forces aimed at promoting diversity in the legal profession. The profession's desire for more diversity is expressed in articles, pipeline programs, scholarship programs, and mentoring programs, and yet, in the quarter of a century that I have been in this profession, we have failed to move the needle on racial diversity in any meaningful way. Microsoft, though, recently commissioned a study of this underrepresentation of minorities in the legal profession, and Michael is going to help me show the slides from this study. The study was called Raising the Bar, an analysis of African American and Latino diversity in the legal profession. Next slide. Perhaps our profession's, commitment to diversity is questionable, but if you look at the literature and the resources that have been devoted, I have to believe that we have a genuine interest in diversifying our profession. I'm not the only one that argues that a diverse profession will strengthen both the quality of justice and our democracy. Microsoft looked at literature when they did this study, and you'll see they drew that conclusion as well. They also note the business case for diversity, that law firms acknowledge that having diverse lawyers in their firm makes it possible for them to get more clients that value diversity, and more clients, of course, yields more income for the firm. And so the business case for diversity is quite strong as well. Next slide. So in 2012, people of color were nearly a third of the labor force, and the United States is becoming more and more diverse every year, but the legal profession is not. So the gap between diversity in the legal profession and diversity in the US has gotten worse over the past 9 years at the time that this study was done. And so you know, there's been a lot of attention to what we can do to, one, prevent a reversal of where we are now, and two, to improve the diversity of our profession. Next slide. So Microsoft commissioned the study to compare rates of diversity in comparable professions, because the thought, well, maybe you know, diversity is just really hard to get in professional ranks because, you know, you have to get higher education, oftentimes more than one degree. You have to pass licensing exams. And so they looked at other professions where high levels of education were required, as well as licensure, and found that we still underperformed. Next slide. So you can see that attorneys, the legal profession, we underperform when compared to the medical profession, finance, and accounting. And so between 2003 and 2012, the percentage of underrepresented minorities employed in the legal profession grew less than 1%, only 0.8%. Next slide. So the takeaways were that although careers in medicine, business, and law are similar, they don't yield comparable outcomes. When we look at minority employment in the legal profession, it basically had not kept pace with minority employment in other professions. Similar professions were doing a better job than the legal profession. And a few of the takeaways were license passage rates are significantly higher in medical fields. So African Americans and Latinos were passing the medical boards at a higher rate than they were passing the bar exam. Loan forgiveness was more readily available and better established for medicine than for law. And there were no national law scholarships on the scale of medical and business scholarships available to students. And so some of these differences could be causing more students to gravitate to business and finance and medicine over law. Next slide. So the study concluded that we needed to prime the pipeline, and that we all have to basically work on our segment of the pipeline that we're aligned with. So for law school deans and administrators, we need to work with undergraduate schools in the recruitment of students, and we need to work with law students to ensure that they navigate the pipeline through law school successfully, and that they get prepared for the bar well, and so that they can be licensed through a bar exam. Next slide. So a critical first step to address the worsening gap in the legal profession, the study concluded, is improving bar passage. But you know, I kind of want to push back against that. So the study says the only national study of bar pass rates by race and ethnicity was done by the Law School Admission Council. The Law School Admission Council has done fabulous work on diversity for, all the years that I've been in the profession. And you can see this study dates back to 1998. And that study showed a significant proportion of underrepresented minorities who graduate from law school do not pass the bar. And so this study by the Microsoft Commission concluded that we need continued research into bar pass rates, and noted that the only state to report admissions based on ethnicity is California. So we know from, for example, I think the February administration of the California bar, only 5% of the African Americans who took the California bar exam passed the exam, but other jurisdictions that fail to collect racial data on bar applicants essentially hide their state's exclusion of racial minorities from the bar. So they hide that data from view of the public. So we don't know the extent to which underrepresented minorities are excluded from the bar in most jurisdictions. It would be helpful if we, if that information was collected, that we could see then which jurisdictions might be doing better than others, and we could learn from those jurisdictions what they could do better. But I want to push back against the Microsoft study, because it assumes that we have a profession that continues to exist as it exists today. And so I want to push back against that a little bit, because the bar exam is touted by most lawyers as this necessary consumer protection mechanism for ensuring that individuals are competent to represent clients in the jurisdiction where they seek to be licensed and practice law. But a recent study that you may have seen on comparing diploma privilege in Wisconsin to licensure through the bar exam found that the bar exam is not a superior tool for ensuring competency to practice law and protecting the public. So in other words, the public in Wisconsin doesn't suffer any more detriment at the hands of lawyers than the public in jurisdictions that use the bar exam for licensure. So I want to push back against this notion that the bar exam has to be the exclusive method of licensure for attorneys in U.S. jurisdictions. So if the bar exam is an exclusionary tool that we know is highly effective at excluding underprivileged people, and particularly racial minorities, then my question is, why do we adhere to it as the exclusive method for licensure? So many legal scholars have noted that the bar exam really measures privilege more than competency to practice law. And the privilege that it measures is, for example, the privilege of being able to study for 3 or 4 months without needing to work, part-time or full-time, to pay for your food or your place to live. The privilege of being able to pay thousands of dollars to a commercial bar preparation company that will present you with past questions from bar exams, along with answers explaining why certain answers are wrong and why other answers are correct. The privilege of having a safe and quiet and comfortable place to study day after day without disruption of other household occupants who would maybe disrupt your train of thought in trying to study. And the privilege of not having to care for a family member while you are trying to prepare for this licensing exam. So, if you are someone of means, then it's not very difficult to meet these requirements. But if you come from a background where you do not have the means to not have to work while you're studying and to hire someone to care for your children or your loved one that you're responsible for caring for, then you are at a disadvantage when it comes to preparing for the test. If you don't have the funds to pay for a commercial bar preparation course, you are at a disadvantage. So why is it then that we stick to this exam as the exclusive method of licensure? I'm not really sure. In my mind, the pathway to a more diverse profession is to have more diverse pathways to the profession. And I think this year we started to talk about what some of those might look like, because COVID-19 forced us to think beyond the bar exam, because we were confronting the pandemic, and the question was, should the bar exam be administered during the pandemic? But I want to challenge us to think creatively, beyond the pandemic, when we are, hopefully post COVID-19, because I think that this conversation has had some value that could bring meaningful change to the profession going forward. If we think creatively, diploma privilege doesn't have to be a concept that can just provide emergency temporary relief in a pandemic. If we think creatively, diploma privilege could be a rigorous form of licensure that provides protection to the public. I can imagine a system of diploma privilege that would provide state-specific preparation for practice that is tested over a longer period of time than a single bar exam administered on 2 or 3 days. I can imagine law school deans sitting down and partnering with the high court of the state to work with the court to determine a state-specific curriculum that integrates state-specific law into courses that would prepare students for practice in that state and give them knowledge about the law in that particular jurisdiction. I can imagine a diploma privilege curriculum that would require everyone who wants to be licensed in that state to have actually practiced under the supervision of a clinician on the faculty, or a practicing lawyer in that jurisdiction in an externship for a certain number of credit hours to ensure that the student, subsequently graduate, is capable of taking that classroom knowledge and applying it in a real world context. I can imagine courses that include modules on state-specific law, such as Kansas constitutional law module in the constitutional law course, or a Kansas family law module in the family law course. I can imagine adding to that foundation through that applied learning that would happen in the clinic. And I can imagine the bar saying students would have to meet a certain GPA threshold in order to earn a diploma privilege. If we think broadly, I think we can imagine another pathway to the profession. In this model of diploma privilege that I'm envisioning, a recent graduate would arguably know more about the law of the given jurisdiction that they're going to practice in than a graduate would by taking a generic law curriculum and taking a generic bar exam, like the uniform bar exam, that does not test the law of the jurisdiction where the graduate intends to practice. I can envision another way to licensure as well. During the pandemic, apprenticeship was discussed as a particular potential pathway to the profession. For graduates who want to pursue this pathway to the profession, I can imagine a period of time, perhaps a year after graduation, that the graduate would work under the supervision of a licensed lawyer in that jurisdiction who would help in their training and help them learn to apply the classroom knowledge that they have gained in law school in a real world context. That licensed lawyer would then certify that graduate for licensure after completing the requisite term of supervised practice. To be sure, the bar exam is more efficient than either of these alternative means that I'm suggesting. The bar exam is a very efficient way to test minimum competency, and the portability of the uniform bar exam is a particularly attractive feature that I wish would have existed when I took the bar exam. So that could entice many law school graduates to prefer the bar exam as a path to licensure. So my argument is not to eliminate the bar exam altogether, but rather to diversify the pathways to the profession by adding additional pathways to the bar exam. By adding diploma privilege and apprenticeship as additional pathways to licensure, the profession could create additional opportunities for law school graduates to prepare for the practice of law and to demonstrate competency to practice law. Retaining the bar exam as the exclusive mechanism for attorney licensure in the face of the data showing its disparate impact on Black and other minority law graduates is a choice. It's a choice to exclude Black and minority law graduates in disproportionate numbers. If Black lawyers do really matter to our profession, we can and should do better. We can and should choose otherwise. So with that, I want to open it up for conversation with the participants and invite you to share your thoughts and your concerns, your questions.
I have a question and a statement.
Yes.
I wanted to first thank you so much for the exhaustive research and the perspective that you bring to African American lawyers in the profession. I sent you a chat about a lawyer who graduated from Howard University in 1948. His name was Julius Robertson, and he had some groundbreaking Supreme Court cases, one of which was cited by Robert Kennedy, public transportation in the United States, and he was my grandfather. So I just wanted to just say thank you for bringing awareness. The bar is basically a legal monopoly, and if the firms choose not to hire the best lawyers, Black or white, or they exclude Black lawyers because they don't want us to have access to the pool of clients in the Black community, able to exert influence on bars across the country. So when I came out of law school in 1988, and J. Clay Smith was one of my professors as well, we faced some obstacles in terms of being able to have access to employment opportunities. And I think that the firms created barriers. I think there were barriers in some of the agencies, and there weren't of us back then in the Jurassic period when I came out of law school. So that was all I wanted to say, and just thank you so much.
Thank you for that reference, Julianne. I think you make a good point that, you know, if we do add additional pathways to licensure, I would hope that employers would not engage in discrimination based on how people are licensed, right? Because the license should be a license, should be a license. So, but that's a great point. I appreciate that. Any other comments or?
I will go to that area.
I could barely hear that. I'm sorry. I don't know if the person wants to repeat that. I missed it. Michael, do we have anything in the chat?
We do not.
Hey, Dean Pratt, can you hear me?
Yes. Hi, Dwayne.
How are you doing?
Joining us.
No problem. I have a question. So it's kind of two parts. The first one is, will we have access to the slides you just showed? Because I think that was really good information. So if we can get access to that, I'd appreciate that. That's just, hopefully we can get that done. The second question has to do with Professor Wilkinson's concept of bleached out professionalism. And I think that's a really important concept because, particularly in law school, you have our conservative friends which believe what they believe. But even when I went to law school at Penn State, my white liberal allies signed on to this bleached out professionalism as well. What could we do as a profession to encourage more color conscious in the profession without getting the sense that we're lowering standards? Because I think that's the false dichotomy we're presented with.
Yeah, great question. So I think there was a session earlier today that talked about basically building an anti-racist law school. And so I think that we have to do that work starting at orientation and beyond. And I think Dean Danielle Conway at Penn State Dickinson is going to be talking about what they're doing with respect to building in an equal protection requirement into the first year curriculum. So I'm really eager to hear her presentation and hear what they're doing along those lines, because I think we could do that work in the various courses that we already offer, right? If we offer a race conscious lens. I want to put a plug out for Dorothy Brown's book that teaches how to teach from a critical race perspective each of the first year courses. And so I think teaching from a critical race perspective brings race consciousness directly to the classroom, and it provides an opportunity to talk about how being race conscious is not the same as being racist, right? Because a lot of students really don't understand that distinction. I think we have an obligation to teach that from the outset.
Thank you. Thank you for your presentation.
Thank you for coming, Dwayne. Any other comments?
There is a question in the chat. Did you want me to read it, or do you want to read it yourself?
Please. Yes, I'm not seeing the chat, so please.
Okay. So the question is, what can we as white allies do to help check the privilege of the bar in subsequent decisions, like hiring decisions by firms that are based on the privilege of passing the bar?
Yeah, so I think we need to work collectively to create additional pathways so that it's not all about the bar. You know, I'm oftentimes reminded of the students that I've seen who were admitted to law school off the wait list with, you know, a lower than desirable LSAT score. And I can tell you that I've personally witnessed so many of those young people become successful lawyers, not just competent getting by, but highly respected, successful lawyers in our profession. And so, you know, when I've talked to those people, I was privileged to work with Dorothy Evanson at Penn State to do a study on African-American law students and lawyers. And when we talked to them, many of them said, you know, I don't test well, you know, whether it be stereotype threat or lack of privilege because they didn't have the resources to take a prep course. And that was, you know, that study was done before LSAC created the wonderful partnership with Khan Academy so that there's now free access to free LSAT prep. But a lot of students say, you know, I don't test well. And so if you are someone who has had that experience throughout your academic career that you don't test well, you're already going into the bar exam, right, with a disadvantage. And so you might choose to say, you know what, I want to pursue diploma privilege. I'm going to take the rigorous specified curriculum instead of the courses that I, you know, would choose on my own. I'm going to take this specified curriculum that will be rewarded with licensure at the end of my academic time in law school. And so I can envision that we can create diversity through additional pathways. And so I would say work with the folks in your jurisdiction to start the conversation with your high court, because the high court in each jurisdiction usually has the power to define the pathway to the profession, the pathway to licensure, what that's going to look like. And so I think we have to start those conversations there. And I think allies will serve an important role. One of the things that I always say is that, the advancement of racial justice at every stage, whether you're talking about the end of slavery, the end of Jim Crow, every step on this march toward racial justice, there have been white allies helping. And so it's critical that we continue that partnership toward racial equality. Let's see, is there a way to access the recordings later? I defer to Michael on that.
So we will let the organizers, yourself being one of them, know when the recordings are available, and then I suppose you all will let us know how you want them made available. So I will say to those of you who are participating, you should probably get a communication letting you know how these will be accessible. How's that for a non-answer?
That's a perfect non-answer. Yeah, so they're going to be made available to us, and I'm sure we'll come up with a platform for disseminating them to everyone. We may ask Verna to create a platform on the Cincinnati Law School website. About how the LSAT rank of law school attended are poor measures of how proficient an attorney. Yeah. So I think Sophie makes a great point. I listened to the Malcolm Gladwell podcast because I love Malcolm Gladwell's books, and I was just laughing because he was talking about how crazy it was to have to take this test under these horrendous speeded conditions, right? And he was like, I don't understand why I have to rush through this. No lawyer is going to practice law like this, is going to be, setting the timer and rushing through, the reading of the client's file or the cases or anything. He's like, this makes no sense. And so he kind of highlighted for us how the inability to do well on the LSAT doesn't necessarily mean you're not going to be a good and successful lawyer. And so certainly thanks for that addition, Sophie. That's one of the other things that I think we could do is, and I've talked to Kelly Testy at LSAC about this, is to invite a non-speeded version of the LSAT, so that if a student takes the LSAT and doesn't get the score that they think they can achieve without being under those rigorous speeded conditions, that there would be a non-speeded version. And that would provide some additional information to law schools, because then if you took the non-speeded version and say increased your score by 10 points, then we would know, hey, this person has the capacity to do the analytical reasoning and the careful reading and engage in the reading comprehension that's needed for law school. So this person has the ability to do that work. They just didn't do as well the first time because of the speeded nature of it. And so that would be the ideal candidate to give the shot to, right? Instead of, guessing, okay, which of these people who have the lower LSAT score are we going to pull off the wait list, for example, or, so I think the more information that we can provide law schools, the better. And while the LSAT isn't, might not be a perfect predictor of success in the profession, it does tell us quite well how students are going to do in the first year of law school. And the last thing any of us want to do is to admit someone to law school and take their tuition dollars and then have them not succeed. And so we do have to be mindful of that. All right, well, any other comments?
Is it okay if I say something?
Absolutely.
Well, thank you so much for this presentation. It's really, really insightful and really good. I also wanted to point out one other subsection when we talk about diversity. Sometimes we miss people who are disabled. There are Black disabled lawyers as well. And so that sort of is one of the layers to this. There are people who have, for example, ADHD, and so they would have a tough time testing. And of course, we have the first, I forget her name right now, but she graduated from Harvard, the deafblind lawyer, very popular one. And so, there's just a lot of work, I guess, still yet done in this profession. I'm not a lawyer like some of you that I've heard, but I'm going to be taking the LSATs. But the reason I'm going into law is because of the sort of disability accommodations or lack thereof I see in schools for kids. And the most marginalized are Black disabled children. And so it just starts all the way from PK all the way up to, post high school, grad school. I mean, whatever you want to do, whether you want to be a lawyer or even a doctor. So that's sort of what I think as well.
Yes.
So I would love to see that. And I would love to see more of that data being stratified by race in other states like California does. So that would give us some really, really good data points to know where to improve. So that's all I want to say. But thank you so much.
Oh, thank you for that. That is such a great comment, and I'm really thrilled that the LSAC does not flag students who take the test with accommodations now. So we, as law schools, don't know if you're applying to law school and you took the LSAT with an accommodation. We don't know anymore. So I think that's a good outcome, and it will provide more opportunity for a student with disability, because the fear was that, if a student was flagged as having took the test under non-standard conditions, that law schools would discriminate and say, oh, they didn't, take the test under standard conditions, so we're going to discount their score that they achieved. And so, so I think that's a good development that has happened.
Dean Pratt, I know William Payne has been trying to pipe
William.
in.
Hi, Dean Pratt. Thanks so much for your presentation. Can you hear me?
Yes.
Okay, excellent. Yeah, really enjoyed it. My question was, what advice do you have for Black 1Ls or other minority 1Ls or 1Ls or other law students in general? Just in general advice and also advice in terms of diversifying the profession and people can contribute in that way.
Okay, so I think my first piece of advice, when I did the study with Dory Evanson, what we found was that race still matters in law school, and that being a student of color at a predominantly white institution oftentimes means that you have to carry some baggage that white students don't have to carry around race. And so I want you to know that you're not alone. And I want you to know that you can do it, and that you're going to have a moment where you may suffer a crisis of confidence and think, am I doing the right thing? Just hang in there. You can do it. And we need you in this profession. And so, if you find you're questioning, talk to somebody who is on the other side. Just talk to a second year or a third year or a recent graduate who's enjoying their career, because not only does the profession need you, but I can say that I needed this profession. It has changed my life, and it's been a wonderful experience. And I think the profession has just so much to offer us as young professionals who want to impact our society in a positive way. It really is that vehicle. You can do that. So congrats on being in law school, and just work hard.
Thank you so much, Dean Pratt.
All right, did we miss anybody? Well,
Nobody else in
I
the
think
chat.
well, thank you all. I don't think we missed anybody. I think our time is up. Thank you all for joining and tuning in, and I hope you enjoy the remainder of the presentations. I've certainly enjoyed participating today.